Listen to me. If you own a home, and it is your biggest asset, and for most of you, it is, you are sitting on a ticking time bomb if you haven't planned for what happens to that deed when you pass away. I want you to look at me. Do you want your children, your spouse, or your best friend to spend the next 2 years sitting in a cold probate courtroom, paying thousands of dollars to lawyers just to get the keys to a house you already paid for? No. You don't. But here is the problem. You're afraid. You're afraid that estate planning is too expensive. You think you need $3,000 or $5,000 just to talk to a lawyer to get a living trust. And because you're afraid of the cost, you do nothing. Doing nothing is the biggest mistake you can make with your money. Today, I am going to show you how to take control. In many states, there is a powerful, beautiful little tool called a transfer on death deed, or a TOD deed. It is the beneficiary designation for your home. Just like you named a beneficiary on your bank account or your 401k, this deed lets you name exactly who gets your house the second you pass away, without a lawyer and without probate. Now, you have to ask yourself, Susie, is this legal in my state? Right now, about 30 states plus the District of Columbia allow this. If you live in a state like Texas, California, Florida, where they call it a ladybird deed, or Arizona, you can do this. If your state doesn't allow it, you need a living trust, but if it does? This is your golden ticket to simplicity. Here's the fear I know you're feeling: if I put my kid's name on a deed now, do they own my house while I'm alive? Can they kick me out? Can their creditors take my home? The answer is a loud, resounding no. That is the beauty of a TOD deed. Unlike joint tenancy, where you give away half your house right now, a TOD deed gives them nothing today. You keep 100% control. You can sell the house, you can refinance it, and you can change your mind and cancel the deed tomorrow if you want to. Your beneficiaries have zero rights until you are gone. So, how do you do it without a lawyer? You have to be meticulous. If you mess up one word, the whole thing is trash. First, you need to find the statutory form for your specific state. Do not just download a random form off a Google search. Go to your county recorder's website or a reputable legal site like NALO. This form will ask for the legal description of your property. This is not your street address. I don't care if you live at 123 Main Street. The legal description is that long, boring paragraph on your current deed that talks about Lot 5, Block A. You must copy that exactly. If you miss a comma, you're creating a nightmare for your heirs. Next, you must name your beneficiaries by name. Do not write my children. Write John Doe and Jane Doe. Be specific. Then, and this is the part where people fail, you must sign it in front of a notary. But wait, there's one more step that is the most important of all: you must record the deed. If you sign that paper and put it in your desk drawer, it is worth nothing. It's garbage. You must take it to your county recorder's office or the registrar of deeds and pay the small filing fee, usually $20 to $50, and get it stamped. It must be recorded before you die. I want you to understand the why here. We are doing this to protect the people you love from the probate predator. Probate is public, it's slow, and it eats your equity. By recording this TOD deed today, you are giving your family an automated transfer. When you pass, all they have to do is take your death certificate to that same county office, file a simple affidavit, and the house is theirs. Done. No judge, no lawyers, no fees. But stay with me, because there is a catch. A TOD deed does not wipe out your mortgage. If you owe $100,000 on that house, your daughter or son inherits that $100,000 debt too. They need to be prepared to keep making those payments or sell the house. And if you have a very complicated estate, maybe you have 5 properties in 3 states or a child with special needs, then yes, you need a trust. But for the average person who just wants to make sure their home goes to their kids without a fight, this is your actionable takeaway. Check your state laws today. Find that form. Copy that legal description. Get it notarized and record it. Do not wait until you are sick. Do not wait until next year. You do this now so that you can sleep at night knowing you have been a responsible steward of your wealth. You are the master of your destiny. Stand in your truth, protect your home, and keep your money out of the hands of the court system. You can do this.